Hello friends, welcome to VSP Law channel. You are watching VSP Law channel. Thank you for clicking this video friends. Today topic is injection. So suit for injection. So under this topic we are going to discuss the point wise. What is the meaning of injection and what purpose injection is filed by the party and what reliefs are available under injection and where it is filed, what remedies available to materialize injection. These are the points we are going to discuss friends. So come to the topic friends. Generally we are listening the word injection. So in medical terminology we are already listened word injection. So but in legal terminology injection is different friends. Here is the injection is granted by the court against a party who is trying to occupy illegally other land of the party. So then what is the meaning of injection? Only the meaning of injection is that to restrain the stranger not to enter into the peaceful position and enjoyment of the certain property is known as a injection. Simply injection means stop or restrain the other party who has not a right to enter into the land of original party is known as a injection. Simply the injection is stopping and restraining the party who has not a right to enter into the certain land. So how many types of the injection friends? Here is the two types of the injection is available. The categories of the injection: temporary injection and permanent injection. What is the meaning of temporary injection? Simply temporary means is a limited purpose. Injection is valid for a limited purpose is known as a temporary injection. So if the injection is valid as a permanent basis, that is called permanent or perpetual injection friends. So the purpose of the temporary injection only valid for certain period. Here is the till the disposal of the main suit. So come to the permanent injection is the valid for a lifetime. Once we are getting a permanent injection. This is the difference between the temporary injections and perpetual injection or permanent injection. So when the injection is rise, so here is that when the parties have any litigation means any disputes in a certain land, that time injection will be arise friends. It means if any party having the original title and original owner of the certain land and is in possession of the certain land, then other party who is not have a right or is completely stranger is trying to occupy his land, then the original owner of the certain land is have a remedy to file a suit for injection to restrain that stranger not to enter into the his peaceful position of the land. Then what steps is needed to taken? So first of all, the original owner here is the right, having the rights. He can approach the civil court where it is engage an advocate and he can disclose the real facts to the advocate and submit his original documents. Here is important. Original documents means simple sale deed, registered sale deed, and pahanis and revenue records, passbooks, etc. Whatever it may be. must be relevant documents and market value of the certain land. These are the documents should be handed out to the concerned advocate. So that after receiving the documents and feedback from you, the learned advocate will prepare a notice and issue the notice to the other party. So call for reply. Maybe given a 10 days or 1 month time. So here is the point is that whether it is the issue of the legal notice is mandatory or not, it is optional, friends. Without issuing the legal notice, you can file the suit directly. So it is better to give the legal notice. And then after completion of the legal notice process, the step is that other party is not listening the not taking care of notice, then is another only option is that file a suit for injunction against the other party. So here remember, those who are filing the suit for injunction called a plaintiff, against whom the suit is filed is called a defendant, friends. So that what steps is needed to file the suit for injunction? Generally, first of all, give the wakalat and relevant documents, and advocate can prepare the plaint. We already discussed plaint, friends. In plaint in which court name and place of the court, number of the case, cause title. Here is the clause title is the plaintiff detail, name of the plaintiff, name of the defendant, and provision. Subject matter must be mentioned, friends. Suit for, here is the suit for injunction. Suit for injunction or restraining the so and so party not to enter in the so and so service, the survey number so and so so and so. Then after that you have to mention the plaint under section 26 rule read with order 7 rule 1 of the CPC. And under that, paragraph brief fact of the case. Before that, description of the plaintiff and description of the defendant, friends. Description of the plaintiff. Here is the name of the plaintiff, address, age, occupation, and the name of the advocate should be mentioned. And description of the defendant, details, name, how many defendants are there, defendants. And brief facts. Before going to brief facts, you have to carefully observe the documents. And first of all, introduction of the land ownership, how the person is got a ownership, and whether through sale, registered sale deed or simple sale deed, whatever it may be. Then what about the position, and this wise paragraph wise. And next is the disputes, cause of action, and these are the plaintiff. Brief facts. As per case, you have to prepare the brief facts. After that, cause of action, and cause of action means is that when incident occurred, when legal notice is issued. These are the cause of action. And limitation and jurisdiction, then after, and valuation. Valuation, remember here is that on base of the market value of the issued by the sub-registrar, then on that base market value, on the market value court fees will be paid. Valuation. Then after prayer, here is the prayer, you can ask the prayer, registering the party so and so, parties not to enter into the suit to survey number so and so land in survey number. And after the plaintiff's the other reliefs, if any, and plaintiff signature verification, other counsel, other advocate will be verified, and your advocate will be made a signature. Then after list of documents must be, remember, list of document must be added as a date wise, and true copies must be attached, all relevant documents. And then after you have to make the schedule, property schedule, and you can give the affidavit section 26 up to of the CPC, give the affidavit, friends. affidavit must be given by the plaintiff. I already filed so and so suit, and in which I mentioned the contents are true and clear. There is no fraud. That is that information given by the plaintiff as a defendant. And next after, if we want a temporary injection, you can file a petition. That is called IA. Order 39, Rule 1 and 2 of the CPC. Here is that temporary injection is the same like pattern, but here is the petition. You have to mention the clear affidavit along with the petition, friends. So then what are the facts mentioned in the plaint that should be carried forward to the petition only, part parcel of the plaint. You can ask the temporary injection, and you can mention the schedule also. And next one, the process already, if it is a list of documents separate, you have to mention, attach that, and process form for suit for sending the summons to the defendant and notice to the respondent, that purpose process. What fees will be paid. And then after, so you can file it in concerned court, either in online section or manual. So that after that, summons issued to the. So if it is urgency, they could file another petition called out of order under section 57 of the CPC, Civil Procedure, Civil Rules of Practice. Then the same day, the court will be hearing. If it is prima facie case made out and balance of convenience in favor of the plaintiff, the court will be granted ad interim injunction. Remember, ad interim injunction will be valid till the disposal of a case, but it will be continue by filing the memo. You can file the memo. Your advocate will file the memo. It will be continued till the disposal of the case. Remember, otherwise it will be lost. Okay, remember. And then after, summons and notice will be sent to the other party. Other party as a defendant or respondent will file a counter double written statements by engaged advocate giving the wakalat. So there is time is available to defendant respondent to file a counter or double S, friends. After filing the double S counter, then trial will be proceeded. And in trial proceedings, plaintiff will lead evidence as a PW1, PW2, PW3. And after closing of the plaintiff evidence, they will call for defendant evidence DW1 and DW2, DW3, like that. After closing of evidence both sides, the court will hearing the arguments from both parties of the counsels. And after that, case will be disposed as a allowed or dismissed. If it is allowed, judgment and decree is available. And if it is dismissed, then you have the option to prefer the appeal to the appellate court. These are the suit for injunction, friends. It will be filed in civil courts only. So if once injunction, permanent injunction is granted by the court, it is a permanent relief available to you, lifelong. It will be continued forever, friends. Remember, in every civil cases, in every suits, there is a permanent injunction will be a relief asked by the parties, friends. These are the topics. That's all, friends. I hope you will get satisfied. If you are satisfied, you will give the like, share, subscribe, and click the bell icon, friends. Please forward to the social media, and thank you for watching this video, friends.